All right. All right. Welcome back to another episode of Talk Lex. I'm Scott Peterson. Geraldo's here with me today. We have another special guest today. Our first repeat guest on the Talk Lex podcast because his last podcast was so well received. I don't know if I told you, it's our highest, most viewed and listened to episode to date, Kevin. So I think that people either really like you. It's certainly not me that's driving it. So I appreciate you coming back on. Kevin O'Brien's here. Kevin's a criminal lawyer in the Capital Region, someone that I've known for several years, and we think very highly of from a criminal perspective, and someone who's not afraid to kind of speak his mind on some of the kind of interesting issues that come up in that capacity. Kevin, maybe you can give just a little bit of background for people who didn't listen to the first episode about, kind of who you are and what you do.
Sure. I'll kind of just go kind of in reverse. I have my own criminal law practice now that I work with my partner, Adam Eggleston, who's terrific, and Taylor Cowan, who's our paralegal and office manager. Prior to that, I'd done some criminal defense for a couple other firms, and I'd been a prosecutor for about 3 years. All of that after graduating from Albany Law and Binghamton University. So that's kind of where we are. I think I've spent, if I was admitted in 2006, I would say that all but maybe those 3 years as a prosecutor and maybe 6 months have been criminal defense. So it's been a good run of criminal defense, and I still like it quite a bit.
Yeah, that's good. I imagine it never ceases to be interesting. I'm sure there's a lot of very different scenarios that kind of come through your world day to day. We wanted to kind of bring you on initially to talk about bail reform. And one of the reasons we thought of this is because obviously we're just coming off an election season, and there's a lot of talk on social media, in the news about, the increases in crime throughout New York State, throughout the country over the last couple of years, basically since COVID, it seems. And most people don't really understand how the bail system works in New York, but I think there's at least some claims or attributions to bail reform as contributing to violence or violent people being out in the street in New York. I don't know if that's true, but we don't practice in this world. So we were curious to hear kind of the perspective of someone who practices in criminal law about, how that system works. So maybe you could kind of talk about, before say 2019, how did the bail system work if someone got arrested? What did that look like? And did it apply in every case, or under what circumstances would bail become an issue?
I guess it was all prior to this. It was really discretionary on the judge's part. There wasn't, as far as I know, any crimes where they could not set bail. Typically, most judges would not have crimes, most misdemeanors, perhaps crimes that didn't have a victim or something like that. But what happened was, and I'm really still kind of trying to process all of the changes and whether I agree with them or disagree with them. But what happened was in 2019, and I think it was put into place early 2020, there was a whole kind of sweeping bail reform legislation that has kind of become a political football that people are playing with. But to kind of put it as simply as I can and as best I can, is it did a lot of really good things, both with discovery and with the bail system, making it less arbitrary and subjective, which also created its own problems as well.
So when you say less arbitrary and subjective, my understanding is essentially the law eliminated cash bail for most misdemeanors and nonviolent felonies. Is that fair to say?
Yeah, it's almost exactly that. There were some things that they ended up adding. I think there was an amendment sometime mid 2020. They added some differences in there, but initially you're exactly right. It was pretty much, it had to be a felony, and it had to have some sort of violence in it. Strangely, the initial thing I believe, and perhaps even still, actually not still, but I think initially like burglary was not included, and some sex crimes, which were really bothersome to, I guess, the public at large, but the potential victims of those crimes.
How often does this come up in the criminal practice? How often is bail an issue?
I would say, for me, even prior to 2020, it was relatively uncommon to have bail. I think the judges were essentially doing most of the things that they're doing now, but with some pockets or different courts or judges who were perhaps being more punitive than and kind of caused this bail reform to come into place. It's interesting. I always try to think of why this needed to be done or why it didn't need to be done. And there are certainly some courts and some judges that I could point to who would use it as a mechanism to keep people, oftentimes poor people, oftentimes people of color, keep them incarcerated while the case is pending. And myself and probably even more so, like public defenders would often be put in the tough situation where the person, if they took a plea, would get out of jail because they had bail set. But if they didn't take a plea, they'd end up sitting there waiting for a trial. And most people are going to take the opportunity to get free and get away from incarceration, given that chance, even if it's not in their best interest legally.
I remember watching or listening to, there was a series, the Serial podcast.
Yes.
And because the way you mentioned it described, and it wasn't in New York, but a couple of, bigger city court systems where judges were abusing the bail system to do exactly that, and to sort of force pleas in a lot of cases. And it seemed like it was a pretty effective way for them to accomplish what it was they were trying to do, but it clearly disproportionately impacted people of lower economic means in particular, I think.
Yeah, of course. And in the way that even the bail now, to me, is completely arbitrary and rather stupid, because they don't have a good means of determining what an appropriate bail would be. So for some of my clients, $20 is like $1 million, and for some, $1 million might be nothing to them, and they would have no problem losing that if they were to skip out of the country or something like that. Those are extreme examples, but people vary widely in what they're able to afford and use in order to get themselves out of jail. And frankly, with the exception of maybe homicides or very serious rapes or something like that, there's not a lot of well-off or rich people sitting in jail waiting for a trial. Most of them are out. They can participate more fully in their defense, and they can be with their family and all sorts of other things. And it's so multi-leveled in what the advantages to being out are. And I totally get the concerns from the other side too, but to me, I've really just been going back and forth on it. But from a practitioner, it's way better and easier for me to be effective if I can meet with my client in the office on a regular schedule with computers and other media that we may need. I during COVID prepared for a murder trial where the best we could do was sit in a jury room with the client, and that was very nice of the judge to accommodate us in that way. But we were trying to watch videos and do things, and the timing's just not the same. I'm sure you're the same, but I meet with clients on weekends. I meet with clients, at 8 o'clock at night. Sometimes you can't do that necessarily when they're sitting in jail.
Yeah, one of the things that Javon and I were talking about before was how much does someone in your position, frankly, how much does it affect, or how much do you care whether your client's in or out? I think you sort of answered that question. are there any advantages from a tactical perspective of having someone who's held in, or is it simply as it's as straightforward as, you know, they're much harder to have good access to out of jail? Because I would think, you know, if they're in jail, there's a central place, they're not going anywhere. You can meet with them. Obviously, it's certainly less comfortable and less ideal for them. I'm just curious.
There probably are. I mean, there's always exceptions to rules. I would say that, you know, one, if you're incarcerated, by law and in practice, you get a quicker trial, which is good. They have to rank those people in front of people who are out. And sometimes, you know, these are kind of exceptions to a rule, but sometimes there may be somebody who, you know, is going to end up incarcerated in one way, shape, or form. During that time period, they're normally able to stay closer to home. They're building up the time that they're ultimately going to have to serve. And, you know, it's easier for their family to visit them and things like that. It's also easier if the client has a bad criminal case, to have a real conversation with them about what the realistic chances of success or ultimately incarceration are. And they're typically more open to those conversations on the inside than they are on the outside, because there's a lot of fear about going to jail and what it's going to be like. And if the person's there, they at least have a preview of what they might be seeing. But overall, you know, if I knew nothing else, I would almost 100% of the time want my client out of incarceration while we're preparing for the case.
Yeah, that makes sense. Is it realistic that clients flee I mean, do you is that something that you see, or is that something that's, you know, made for a Law and Order episode, that, you know, clients are going to flee the area and not present for trial, or not present for you know, for any of the preliminary hearings or anything like that?
It does happen. I think it probably happens a lot less than people think. And strangely, I'm always shocked that people don't flee more frequently. There's some people that I've known, I'm like, they are going to prison. They have the means to go to some place where they're not going to be caught, or a non-extradition country. And I can't understand why they don't. I sort of root for them to run in a weird way, which I know I can't. Ethically, I have to tell them to be there. And I certainly don't tell them to run, but in a weird way, it's like you're cheering for the bad guy in a movie. Like, I had a client, it was probably, a little over a year ago. It was probably the summer of 2021. And I knew he came in on the morning of trial when we're selecting the jury. And he pretty much lambasted me, lambasted the judge, left for lunch and never came back. And he was gone for a long time. They ultimately found him. But even though the client was a very difficult client, I really wanted him to get away and stay going. But it certainly didn't help his case. And I would say that, you know, people run or don't show up for court maybe 5% of the time. It probably lower than that. At least my client.
And so,
I can't speak for like public defenders and stuff like that. It's a different scenario.
yeah, and in those scenarios, is it in your experience, how does it work? So a bench warrant is issued, right? And then is it up to, you know, who makes a determination as to how aggressively they're going to go after someone?
I'm sorry, you were breaking up there a little bit. And it might be,
Yeah.
What?
No, I'm curious, you know, in those scenarios, if someone were to, you know, skip out on bail or flee before a hearing, you know, I assume the judge would issue a bench warrant. And, you know, I'm just curious, like, who determines how aggressively they're going to go after someone? Or is it just a matter of whether the person pops up gets himself into trouble again?
You know, I don't know. It seems random to me. I mean, the more serious the crime, I think the more they're likely to look. I've had clients, you know, who have taken off and maybe they'll be out in California or Idaho or something like that. And if it's a relatively low level crime, the likelihood is they're not going to go pick them up, even if they do get stopped and held. but they would be held for a period of time. I forget the period of time that the other state has to hold them until New York has to go and get them or not. I think it's like 21 days, but I might be making that up. So it really does depend on the crime. It depends on the police department. Probably depends on the DA's office too, because if they're really motivated to get them, they're going to be making more calls to the sheriff or the local PD or FBI or whoever they're using to try to find this person.
Go ahead.
That I'm going to finally say something. This just kind of ties in with something that I had read when we were kind of preparing for today that I did not know, and ties in with people taking off when they're out on bail, but also maybe some of the misperception out there about what bail reform did do and didn't do. So what I was reading is that when judges decide to set bail or not, the criteria they're supposed to apply is your likelihood of coming back to court, as opposed to whether you are a dangerous person who should or should not be kind of put back on the streets. Is that accurate?
It's certainly accurate in the way that the law is written and the way that it's supposed to be applied. You never know what's going on in the privacy of a judge's mind. And I do think that a lot of judges do factor in the nature and the charged crime. And I do think they factor in, criminal history. And it really is supposed to be like you laid out, that it's just supposed to secure an appearance. And that's probably one of the most misunderstood things about from the public, because in other states and even federally, they can factor in the person's dangerousness to society. In New York, they're not supposed to do that. And I was reading several things about that in preparation for this, and I was kind of persuaded by both things. So I don't know where I come down on it, but right now, and even before the bail reform, dangerousness was not a factor that judges were supposed to incorporate into their decision.
Right. Yeah. And I don't feel educated enough on this subject or, to have necessarily a certain opinion one way or the other on the bail reform. I mean, I think probably it's not super controversial that, the playing field should be a little bit more, even depending on your economic status for people committing the same crime. I don't think anyone wants a bunch of super dangerous lunatics roving the streets necessarily either. But one of the things that I thought was important to kind of get out a little bit is, is that actually happening or not? And what did the bail reform law change and not change? So I think that piece of it is important. I think for people to know that this is like going back to the 1970s from what I saw, that you don't necessarily take this dangerousness idea into consideration, at least not overtly. So that at the very least is not something that is new from the bail reform, for people to think, oh, we used to be able to take this into consideration and now we, are just letting everybody, out no matter how dangerous they are.
Right. And I think to actually answer your question rather than kind of skirt it, I think judges have always been factoring in dangerousness, and I suspect they still are. What I think that this did, probably more than anything, was kind of sent the judges and the prosecutors sort of a message like, hey, we should try to err on the side of allowing people to be out while they're accused of a crime, and we shouldn't be holding them in unless it's absolutely necessary to secure their appearance. And that's something I really like about the bail reform. And again, I'll acknowledge there are problems with it, but the thing I really like is I think it's been kind of a charade for a long time that we've been playing, that people are presumed innocent while they're sitting in jail wearing orange jumpsuits. And, oftentimes for, I've had clients sit in, jail. It was primarily over COVID, but for more than a year awaiting a trial. And that's not any way that any, I think modern and free country should be operating, if we really want to take ourselves seriously and say that we are giving people the presumption of innocence, which I think is kind of nonsense anyway. I don't think anybody really gives my clients the presumption of innocence, but it's written, and it's kind of one of the foundations of this country. So I think it was a good reminder to judges and prosecutors, hey, they shouldn't be sitting in jail for any period of time that's unnecessary until you've proven them guilty of something.
And I think the point you made earlier was really good. That wasn't really something that I saw come up in the conversation, but just that people who are, sitting in jail for that significant period of time are more likely to take a plea, and then they're going to have something on their record for the rest of their life that I assume can impact them in a million different ways. We do employment law. That's something that comes up.
100%. And they do it. They're sneaky about it. It's annoying because my point has always been, we should be focusing on more serious crimes, where people are hurt or victims or things like that. Instead, we make a lot of kind of low level arrests. We put people away who, maybe are poor or disenfranchised in some way or another. You'll have, I remember even when I was a prosecutor, people would end up doing 15 days on a disorderly conduct, which is, not a whole hell of a lot more than a traffic ticket, honestly. So it's a strange thing. And, one of the things that this got me thinking about, because I do think that it's somewhat coercive in allowing people to, or pushing people to take a plea that may not be in their best interest, or may not be something that can be proven, is they do it with DWIs too, because they take people's license right at arraignment. And, if you don't live in Manhattan or something like that, that's a serious issue for you to have. And none of the time that you're without your license counts towards any ultimate suspension or revocation should you be convicted. So a lot of people will end up taking pleas in that crime, and it has nothing to do with their freedom. So when you add in, incarceration, being away from your family, potentially losing your job, potentially losing your housing, or custody of your kids, that's going to be even more influential than kind of the, which I don't agree with, taking your license on a DWI at arraignment.
Yeah, that makes a lot of sense. That makes a lot of sense. It makes sense why people would take pleas in those scenarios. People need to try to move on as quickly as they can, I would imagine, right? And that's what they say. I want to shift gears for a little bit, because you mentioned something that we didn't talk about before. We may have actually talked about this on the last discussion, which is that I think you said something to the effect of you don't think people are giving your clients a presumption of innocence. Maybe you can go into that a little bit more, and I'm curious about it in the framework of how it's changed, if it's changed at all over the course of your career, in terms of seeing how juries in particular respond to people who are accused of a crime. If social media, if the kind of ubiquity of comments and commentary has changed kind of the perspective of jurors as you see them towards criminally accused people.
Yeah, I mean, I don't want to speak for other attorneys, but I will tell you what's been my position. And my position has been, and I think it's one of the few areas where I haven't really deviated from my original position. I don't think anybody really enjoys the presumption of innocence. When I have people come into my office and they're sitting across from my desk, I tell them, make no mistake, I'm going to give you the presumption of innocence. The people who work here are going to give you the presumption of innocence, and perhaps your family members will give you the presumption of innocence. Everybody else thinks you did something, because most people haven't been arrested. Most people haven't seen some of the injustices that happen more frequently than any of us would be okay with. So the view that I take when I'm going into a jury is very simple. It's, I want them to start to think rather than to just kind of be on autopilot. So one of the things I ask, and I almost never repeat myself, but I do repeat myself in this regard. I often start off with a question like this, like, you know, who walked in this morning and said, damn, there's another innocent man sitting with his attorney at the defense table? And you don't get any positive, or you don't get any affirmative answers there, but you can kind of see, at least with some people, the lights kind of going off in their head and saying, okay. And then I explain it, I'll sit home with my wife or with my kids, and we're watching a movie and we're trying to figure out what happened or who did it, who's going to be the first person to be able to figure it out. Well, that's not the name of the game with the jury. You want them to almost be a blank canvas. And I don't have the delusion that they're really a blank canvas, but if I can get them thinking and at least considering that thought process during the jury selection, I think that we have a much better chance of being successful in the trial element of the case. So the jury selection for me is very, very much about getting them to open their mind up to the idea that my client might be innocent, and not relying on the instruction that the judge is going to give them that, they're presumed innocent. Because, most people, if you walk into a courthouse with somebody, they're like, oh, what did you do? Or what did he do? And that's natural. And it's not even necessarily wrong. It's just wrong when you're a juror judging another citizen of this country.
Yeah, we deal with that in the civil context, in malpractice cases in particular on the plaintiff side. The stakes are different, obviously, and the standard is different, but you're going in, and what I find is when you're talking to juries, the presumption when you're a plaintiff and you're suing a doctor or a healthcare provider is that, you're greedy and you want money and they didn't do anything wrong. And so right out of the gate, we're always trying to reframe the thought process of, can you step aside from your kind of preconceived ideas if you have them, and can you think about exactly, just what we're going to tell you here, and can you look at it from that perspective? And it's easier said than done. I think sometimes people will tell you what you want to hear, and then they'll make decisions however they want to make the decision. But you're trying to cut through that, I think, out of the gate. It's not easy.
Yeah, and I think it's sort of intentional, probably in your view. The insurance companies and stuff sort of have subtle ways of spreading that message. And then I think, and again, I'm not anti-law enforcement or anything like that, but I think law enforcement has subtle ways of doing that as well, because almost everybody knows a cop, and most of them are good dudes that are or ladies that are trying to do what they think is right. But you have to acknowledge that they get it wrong sometimes, and that even myself, and I often use myself as an example. I get it wrong all the time. Especially if I think something happened, I'll put on blinders to the point that I'm missing real information that could be helpful to me coming to the right conclusion, rather than just filling in the blanks in a conclusion that I think is already there.
Yeah, I completely agree with that. Giovanna, before I move on, do you want to talk anything else about on the bail reform issue?
No, I don't think so. I mean, the only thing I want to, again, sort of in a clarification sense, and I might have I know it became a very political thing. I think also because I'm a woman, I kind of get other women coming to me with, a sense of like, our city's unsafe, what there seems to be a lot of crime going on. And I think probably we won't be able to answer that question as to, does any of this have to do with bail reform, or does it have to do with COVID, or is it, a national issue? But I do want to kind of just clarify, because I think you had touched on this, that there were some amendments to the law that came out that really applies primarily to nonviolent felonies or misdemeanors. Is that right? So like violent felonies, sex offenses at this point now are not, like, that's a separate category that we don't necessarily have to say, if we see a newspaper article of this, disgusting thing that happened, sometimes I'm noticing like the knee-jerk reaction to that is bail reform. but I don't know that that's necessarily accurate for kind of a pretty significant category of cases.
Well, they have added some misdemeanors, and those primarily involve, violence and things like that. And then there's also the addition that if you're out, meaning that you've been arrested and you've been released, and then you get rearrested with another crime for another crime where there's a victim, regardless whether it's a qualifying event or qualifying crime or not, they can set bail at that point. So I think those were good additions. The other part is, and you kind of hit on it, and it makes me so mad because most people don't have these kind of long form nuanced conversations. And of course it's not just bail reform, and of course it's not just COVID, and it's not just that people are kind of down and out or the economy is bad or whatever. There's all sorts of factors, and I think to say just bail reform is about as silly as saying just COVID or something like that. People are in different geographies or different states, different cities, all have different contributing factors. And I get kind of screwed up in the reading the statistics, because as I was preparing for this, I looked at some of them, and there was I forget the publisher, but it was a relatively liberal website, and they were talking about how low people who've been released their crime rates are. And then I think the New York, a handful of really violent acts that happened when somebody was let loose because of bail reform. Now, both of those things can be true, but we have to take them. We have to take them and kind of evaluate it and make adjustments where we need to, and try to do that in a way that protects the accused and the citizenry. And it's hard to do in our somewhat broken political system, because everybody wants to score a point or dunk on somebody and say, well, it's because Kathy Hochul did this, or or there's no increased violence. I think you really have to look at it and try to have an open conversation and try to figure out the solutions rather than just pointing to one thing.
Yeah, and it's hard, like you said, it's hard to have kind of nuanced conversations. I think one of the catalysts for us talking about we should, ask you to come on again and talk about this a little bit was because I read an article about something that happened locally that was kind of a worst nightmare scenario for parents of somebody abducting a couple of children out of their house, and that they had met on social media, and there was like sexual assault allegations, and this person was being held without bail. That was very clear in the article, but every single comment on the article said this person is out on the streets because of bail reform. So it was sort of like you're constantly combating this like misinformation all the time, and like on both sides of it. But that was kind of one of the things that sort of precipitated us saying this probably makes sense to talk about.
Yeah, and it's so much. It really is so much more than just one thing. And the once the article is out there, or once the people have their mind made up, it's very difficult to change their mind. As I've practiced longer and longer, am more and more aware of how little I know, and I frequently change my opinion. If we'd had this conversation about bail reform a month ago, I probably would have been talking about it in a different way, because and I think most people should do this, is really be open to having your ideas evolve and listen to people that you disagree with. And if they have good points, you can adopt those points without necessarily adopting all of the things that they say.
Right.
100%, 100%. You mentioned earlier, in addition to bail reform, there were some changes in the disclosure laws, and I kind of wanted to talk about that a little bit. I don't think most people have any understanding of what the government has to prove, A, and B, for the purposes of this conversation, what the government has to do if they charge you with a crime relative to disclosing what they intend to prove. And I always, whenever I think about this, I think of that scene in My Cousin Vinny, when he says, the prosecutor gave me all his files, and she's like, of course they did. It's called disclosure. You dickhead, right? It's like most people don't know that, but other than maybe watching that movie. So, you get accused of a crime, you have a client. What's the obligation on the state to turn over evidence, and what do you get? What do you expect to get, and sort of what's like the time frame for that?
This is actually one of the things that came through that kind of legislation that I think was really a good thing. And most of the local DA's offices were already kind of complying with it to a large extent anyway. So, but there's places like Columbia County where we would have to really pull teeth to get even half of what we were entitled to. So the way that it was before, you had to file discovery demands, and the people had to respond to those. And to a large extent, with a few exceptions, if you didn't ask for it, you weren't necessarily going to get it legally. And there may be some disputes about what needed to be turned over or whatever. But the bail reform legislation kind of changed discovery completely, and it made it almost automatic. And it's supposed to be, I believe it's 14 days from arraignment. That hasn't been necessarily adhered to perfectly. They can file supplemental discovery, and I sort of understand that in the sense that there's blood work sometimes, or testing of drugs, or fingerprints and things like that. But the idea is that a client or an accused person needs to have all the information and all the evidence against them before they can intelligently make a decision about how to proceed on their case. So even after you get all of the discovery, there's, again, I'm not great with dates, but I think it's like they've got to give you at least 3 days to make a decision on offers and really evaluate things with your clients. Things like video are automatic. Things like police reports, statements, audio, really the things that you would be looking for. I don't have an expansive list, but most of the stuff that we would have been requesting before, and even some other stuff, like before we couldn't get police disciplinary files, and now that's a part of it, which is a real big deal. And it just allows an accused person to have a better understanding of what they're being accused of, what the evidence is against them, and then crafting a way to be able to defend that case, or at least try to negotiate something better with a complete picture. Because before it was like, a half-done puzzle sometimes. You'd get an offer and they'd say, we need to know within a week, and you don't even have all the discovery, which really makes people, it's tough because memories are flawed too. I don't think necessarily all my clients are lying, but sometimes they don't know what their criminal history is, or they don't remember the act because it was intense or traumatic or whatever, as well as they might like to. And so there we at least get to see everything they have, and it allows me to make a better recommendation to my client. It's not that I'm going to lean on them or make them do something, but it at least allows us to have a clear picture of what's coming and what we think we can do from there. So that's a lot better. And that's one of the things that, hasn't been spoken about very much. And it really keeps some of the, I guess, more unethical DA's offices in check. And again, most of them were not an issue, but some of them, I feel like the law was written exactly for them.
Well, yeah, I'm just imagining, if you're representing an accused person and you have half the file and they're being given an offer that if they take it, they're going to jail. That puts you and the client in a very, very difficult position. I mean, we handle that, we have negotiations in civil cases all the time, and you try to get a full picture, but depending on the procedural state of the case, you might say to yourself, there are some things we don't know yet, and we're taking those into account when we consider these things. But in those cases, we're talking about money. We're not talking about going to prison and the decision making. So I can imagine that's a serious, or was a serious challenge.
When it was even worse, like, again, and I've referred to Columbia County before, and I only refer to them because I really think that they practice and quite frankly, I still think they practice in an unethical, unfair way out of that office. And it starts with the leadership, who's Paul Chaika. He was a judge and he's been the DA, and he's a very charming, handsome guy walking around the courthouse. But I don't think he's doing good ethical work. And before all this happened, like if we filed a discovery demand, they would either withdraw offers, or because he didn't feel like he could control the local court judges, he would indict misdemeanors and proceed on them in county court, where I again, I'm not in his mind, but I think he felt like he had a little bit better home field advantage because he's working out of the same courthouse. One of the judges used to be his chief assistant. There's a lot of things going on there, and you're like, what is this? Like, why are we doing it this way? Like, if you really think my client's a bad dude or a bad lady, and you've got a good case against them, show me, and then I can come in and I can say, hey, client X, I think you need to take this deal, or I don't think we have a very good chance at trial. But they were always trying to hide the ball, and I think they still do to a large extent, because they're protected by their own judges down there, which is unfortunate. And as probably even slower with you guys, but justice happens slowly, so things are still being decided now from that 2020 legislation.
And I think you want to give, there is some value, like you said, in giving kind of you as the attorney the benefit of the doubt of, if you receive a full picture of what's going on, that's going to inform how you advise your client. I mean, we have that, I would say probably more so in employment cases than PI, but if you think my client did something wrong, tell me, give me, I've had people drag out through like an entire EEOC process, a video of something. And I'm like, why didn't you give me this video 6 months ago? Like, we could have all saved a lot of, time and effort. I noticed in the Southern District of New York, they have an employment cases kind of a analogous system, I think, to what this new disclosure is, which is there's just categories of information that you have to give right off the bat. Nobody has to ask for it. You just give it to them. And I think that's helpful.
Yeah, I mean, I think that it ultimately saves resources by disclosing things sooner and being able to have an open and fair conversation. But part of the problem, and this is always going to be the problem, there's a lot of shit lawyers out there. And, if the lawyer has the full picture but doesn't understand what he's looking at, the client still gets screwed. So I tell my clients that all the time. Like, I want you to be comfortable with me, but you got to be really, really careful with who you hire, because there's a lot of attorneys who are out there who just go in and do what the DA says, especially those that stay in very local areas. And I've never seen that as my job. And I try to be as friendly and decent with people as I can be, but I can't care about anybody else's feelings or time or anything other than my client. And I'll tell them that, that includes their family. There's cases where, a father doesn't want something done to his son. And, if it's in the son's best interest, I don't care what the father thinks. And, even if the father's paying the bill, I can't.
Yeah, and that's, go ahead.
Oh, sorry. No, go ahead.
No, go ahead.
No, I was just going to say, because you were talking about, representing, you just mentioned, somebody's father paying the bill. I want to make sure we get to something that you had mentioned kind of before we got on formally to talk about, you were seeing kind of an increase in, is it like youthful offenders? Is that the right terminology?
Yeah, it's a weird thing. I don't have the exact numbers, but I've been thinking about it a lot lately, because I would say that probably as recently as 2 or 3 years ago, certainly 5 years ago, I might have had 0 or 1 client who was, say, under the age of 19. And right now, in the last year, I would say that I've had more than 10. And it seems to me, and I'm still kind of working it out in my mind, so I don't have a definitive answer, but it seems to me like something is going on where things that used to be disciplined at a school level or at, you know, a home level are now involving the police with young people. And I do not think that that's a move in the right direction. Schools have been despicable to my clients. Like, it seems like they want to kick people out and cover their own ass for whatever reason. You know, because some of the cases that I've gotten, and they vary widely, are these ones where a kid is in school and makes, quote, a terroristic threat. And obviously everybody cares about their kid, but a lot of the things they're saying are things that I've said to my buddies a million times in school and then after school, you know, like, I'm going to kill you, or, you know, I'm going to kill myself, or whatever the case may be. And I certainly understand that we want to address violence and potential suicides and things like that. But I think we do that through education and not kicking them out of school and trying to make them better citizens rather than putting them through the court system at such a young age, where I think they ultimately, it could have real long lasting impacts, in the sense that I don't think these clients are going to trust police as much anymore. I don't think they're going to trust the institutions that are supposed to be protecting them, like the courts and like the school systems. And I just think it's kind of, at least from my perspective, and again, it's always weird because public defenders have somewhat of a different caseload and a different thing. So I don't know if they've been experiencing this thing more than I have, or prior to me experiencing it. But I don't think having kids in court, except for in extreme situations, is a great idea.
That's another total like hot button political topic, probably also like increased police presence in schools. Like, do you feel that there's a correlation between those things, or is it more the school, something's happening at school, the school is going to the police, or other parents are going to the police?
Well, I think that it's a combination of a lot of things. And, you know, probably not a popular opinion, but I'm completely against even having school resource officers. I don't think that it's done anything to help. And frankly, I don't want my children walking around school with a police presence. If we need to, you know, make the school safer, I think we need to do that in a different way. I don't want police officers talking to my child without me around. And I've told them as much, but I think it's more that people are becoming too reliant on the government for solutions, rather than calling their neighbor and saying, hey, your kid punched my kid or threatened my kid or whatever. One of my son's friends a couple of weeks ago, a kid told him he was going to kill him in school. And now that kid's out of school, not my son's friend. He was, in fact, the victim there, I guess, if you want to call it that. It was never going to happen. But now he's out of school for the rest of the year. Like, they just kick kids out of school willy-nilly. And a lot of the times the schools aren't doing the right thing. I mean, I know we're more talking about the criminal idea, but the schools and these family court things go hand in hand. And I think that a lot of the times the schools are calling police on their students, then kicking them out. And then you have the instance where they have to hire me and navigate through its family court, the youth part, which has both good and bad things about it, because you can't technically be convicted of a crime when you're under, I think it's under 19. It might be 19 and under. But the other problem is you're at the mercy of a judge. So if you have a client who has a good case and it stays in youth part, you don't have the right to a jury. So these kids aren't even getting the same rights that their adult counterparts would get. Now the punishments are less, but the problem is if you've got a bad judge on a case, you have to take some sort of deal or disposition to avoid potentially having the child taken away from the parents.
Yeah, you know,
I've never even thought about it. I feel like this is like a whole other
I apologize.
no, that's interesting.
It is. And you know, the irony, you made the comment about parents talking to one another and your neighbors. people are more connected than ever, but less inclined to have those conversations, I think, which is, it's sad. It's unfortunate. I want to be respectful of your time. So I think, I mean, we could pick your brain all day, and this has been great again, as it was last time. Where can people find you if they have questions, if they unfortunately need your services, if their kids need your services, as we just learned, where can they come to find you?
Well, the name of the firm is O'Brien and Eggleston. You can Google us. We're right downtown Albany on Sheridan Street. We practice throughout the capital region and frankly, beyond that. We've got cases, I think right now, as far south as Putnam County currently, and as far north as Franklin County. We go out west, probably all the way to Syracuse or Binghamton sometimes. The way that I do it, and I think I may have even done this at the end of the last thing, I give everybody my cell phone. If you need to get a hold of a criminal defense attorney, I want you to be able to get a hold of me. Obviously, I don't answer my phone all the time, but I'm pretty good about getting back to people. So you can call or text this number if you're ever in a criminal situation, 518-618-5423. So that's the way we do it.
My mind is exploding that you just gave yourself.
Some people calling me, and sometimes I think that that's a bad idea. But you know, the truth is the easier I am to reach, I feel like the less my clients abuse it. So you know, I understand. I've been, you know, in trouble before myself. I understand that you get really, really anxious and really, really nervous when you're accused of something. And most of the time I can put a lot of those fears to rest. And I don't want them to have to wait until Monday morning or, you know, the next business day. If it happens on a Saturday and I can answer my phone or I can give you a call back, I'm absolutely willing to do that, because I think that's part of my job as well, is to kind of get you settled in so you don't do anything stupid, and then alleviate some of the concerns, because your mind runs wild and makes up scenarios that probably aren't even going to factor into your case.
Yes,
Yeah,
I think that's
true.
a good rule of thumb for everyone facing a legal disaster.
Yeah, we see the same thing in our practice.
Who knows?
Well,
Maybe
Kevin,
I change my cell phone before the next time we're on, but I doubt.
I hope not. Kevin, thanks again. I really appreciate you coming on. You know, hopefully we can have you on again for a third time at some point in the future. Thanks everyone for listening. If you have any questions, hit us up on Instagram at TalkLex or visit DeRazioPeterson.com, and we'll be back again soon. Thanks.
Thank you very much.